Commonwealth v. Hunt, 45 Mass. 111, 1842, was a case in the Massachusetts Supreme Judicial Court on the subject of labor unions. Prior to Hunt, the legality of labor combinations in America was uncertain. In March 1842, Chief Justice Lemuel Shore ruled that labor combinations were legal provided that they were organized for a legal purpose and used legal means to achieve their goals. The history of labor disputes in America substantially precedes the Revolutionary period. In 1636, for instance, there was a fishermen's strike on an island off the coast of Maine, and in 1677 12 carmen were fined for going on strike in New York City. However, most instances of labor unrest during the colonial period were temporary and isolated, and rarely resulted in the formation of permanent groups of laborers for negotiation purposes. Little legal recourse was available to those injured by the unrest because strikes were not typically considered illegal. The only known case of a criminal prosecution of workers in the colonial era occurred as a result of a carpenter's strike in Savannah, Georgia in 1746. By the beginning of the 19th century, after the Revolution, little had changed. The career path for most artisans still involved apprenticeship under a master, followed by a move into independent production. However, over the course of the Industrial Revolution, this model rapidly changed, particularly in the major metropolitan areas. For instance, in Boston in 1790, the vast majority of the 1,300 artisans in the city described themselves as master workmen. By 1815, journeyman workers without independent means of production had displaced these masters as the majority. By that time, journeymen also outnumbered masters in New York City and Philadelphia. This shift occurred as a result of large-scale transatlantic and rural-urban migration. Migration into the coastal cities created a larger population of potential laborers, which in turn allowed controllers of capital to invest in labor-intensive enterprises on a larger scale. Craft workers found that these changes launched them into competition with each other to a degree that they had not experienced previously, which limited their opportunities and created substantial risks of downward mobility that had not existed prior to that time. These conditions led to the first labor combination cases in America. Over the first half of the 19th century, there were 23 known cases of indictment and prosecution for criminal conspiracy, taking place in 6 states: Pennsylvania, Maryland, New York, Louisiana, Massachusetts and Virginia. The central question in these cases was invariably whether workmen in combination would be permitted to use their collective bargaining power to obtain benefits, increased wages, decreased hours, or improved conditions, which were beyond their ability to obtain as individuals. The cases overwhelmingly resulted in convictions. However, in most instances the plaintiff's desire was to establish favorable precedent, not to impose harsh penalties, and the fines were typically modest. One of the central themes of the cases prior to the landmark decision in Commonwealth v. Hunt was the applicability of the English common law in post-revolutionary America. Whether the English common law applied, and in particular whether the common law notion that a conspiracy to raise wages was illegal applied, was frequently the subject of debate between the defense and the prosecution. For instance, in Commonwealth v. Polis, a case in 1806 against a combination of journeyman cordwainers in Philadelphia for conspiring to raise their wages, the defense attorneys referred to the common law as arbitrary and unknowable and instead praised the legislature as the embodiment of the democratic promise of the Revolution. In ruling that a combination to raise wages was per se illegal, Recorder Moses Levy strongly disagreed, writing that the acts of the legislature form but a small part of that code from which the citizen is to learn his duties. It is in the volumes of the common law we are to seek for information in the far greater number, as well as the most important causes that come before our tribunals. As a result of the spate of convictions against combinations of laborers, the typical narrative of early American labor law states that, prior to Hunt in Massachusetts in 1842, peaceable combinations of workingmen to raise wages, shorten hours or ensure employment were illegal in the United States, as they had been under English common law. In England, criminal conspiracy laws were first held to include combinations and restraint of trade in the Court of the Star Chamber early in the 17th century. The precedent was solidified in 1721 by the King v. Journeyman Tailors of Cambridge, which found tailors guilty of a conspiracy to raise wages. Leonard Levy went so far as to refer to Hunt as the Magna Carta of American trade unionism, illustrating its perceived standing as the major point of divergence in the American and English legal treatment of unions, which removed the stigma of criminality from labor organizations. However, Levy's statement incorrectly characterizes the case law in American prior to Hunt. Polis was actually unusual in strictly following the English common law and holding that a combination to raise wages was by itself illegal. More often, combination cases prior to Hunt did not hold that unions were illegal per se, but rather found some other justification for a conviction. After Polis in 1806, 18 other prosecutions of laborers for conspiracies followed within the next 3 decades. However, only one such case, People v. Fisher, also held that a combination for the purpose of raising wages was illegal. Several other cases held that the methods used by the unions, rather than the unions themselves, were legal. For instance, in People v. Melvin, cordwainers were again convicted of a conspiracy to raise wages. Unlike in Polis, however, the court held that the combination's existence itself was not unlawful, but nevertheless reached a conviction because the cordwainers had refused to work for any master who paid lower wages, or with any laborer who accepted lower wages than what the combination had stipulated. The court held that methods used to obtain higher wages would be unlawful if they were judged to be deleterious to the general welfare of the community. Commonwealth v. Morrow continued to refine this standard, stating that, in agreement of 2 or more to the prejudice of the rights of others or of society would be illegal. Another line of cases, led by Justice John Gibson of the Supreme Court of Pennsylvania's decision in Commonwealth v. Carlisle, held that a motive of the combination, rather than simply its existence, was the key to illegality. Gibson wrote, "Where the act is lawful for an individual, it can be the subject of a conspiracy, when done in concert, only where there is a direct intention that injury shall result from it." Still other courts rejected Polis' rule of per se illegality in favor of a rule that asked whether the combination was a but-for cause of injury. Thus, as economist Edwin Witt stated, the doctrine that a combination to raise wages is illegal was allowed to die by common consent. No leading case was required for its overthrow. Nevertheless, while Hunt was not the first case to hold that labor combinations were legal, it was the first to do so explicitly and in clear terms.